This is Zara and Luna. They buy a lot of stuff, but they never read the terms and conditions for their purchases. Why not? Well, there are two reasons. First, Zara and Luna are too busy living their lives to sit down and read a contract. A Carnegie Mellon study concluded that it would take 76 days, working 8 hours each day, just to read all the privacy policies the average person agrees to in 1 year of internet use. 76 days, and that's just accounting for privacy policies associated with using a website. It doesn't account for any other terms and conditions associated with online activity or even purchases made in person. Second, even if Zara and Luna did take the time to read the terms and conditions for all those contracts, they wouldn't even understand them. So why bother? This issue is actually not unique to cats. After reading the sign-in terms and conditions of 500 popular websites, two law professors concluded that 99% of the contracts were unreadable to the average American adult. Now, it's typically recommended that consumer documents be written at an 8th grade reading level, but 498 of those 500 consumer contracts required 14 years of education to understand. Sellers know that consumers are not reading the terms and conditions, and this creates an opportunity to exploit consumers and get them to sign away their rights. Commonly, consumers waive their rights to trial instead agreeing to mediation and arbitration. But what's a cat to do? Stop buying things? Or just make purchases and hope for the best? And what happens if something does go wrong? The doctrine of unconscionability is one way that consumers are protected from unjust and oppressive terms. The purpose of this law is to allow courts to police contracts that are oppressive or result in unfair surprise due to adverse construction of the language or manipulation of the rules of offer and acceptance. To win on an unconscionability claim, most courts require both procedural and substantive unconscionability. Procedural unconscionability occurs if the contract is formed from oppression or unfair surprise. Oppression refers to bargaining power that is so unequal that it creates a lack of real negotiation and a meaningful choice. Unfair surprise means that the party seeking to enforce the term has hidden it in the contract in such a way that its existence is a surprise to the other party. Courts also require substantive unconscionability, which is an unfairness in the actual terms of the agreement. Terms are substantively unconscionable when they are so one-sided that they shock the conscience, or when they are extreme under the circumstances, including things like industry context, time, and place. Unconscionability is commonly used in an attempt to invalidate mandatory arbitration clauses, but it's much less commonly used as a tool to void agreements to mediate. Now, this does not mean that mediation clauses are always conscionable. In this video, we'll detail how to use the jurisprudence on invalidating unconscionable mandatory arbitration agreements to argue that a mediation clause in a consumer contract is also unconscionable. For mandatory arbitration clauses, procedural unconscionability has been proven under the following circumstances. First, when employees are told that they must sign the agreement to continue employment or to be considered for promotions, transfers, or raises. Second, employees may not have the opportunity to negotiate such terms. Third, employees do not read or are not required to sign mandatory arbitration agreements. And last, if employees are given no explanation as to what the terms of the agreement means or what the legal impact is, then that could be procedurally unconscionable. Similar arguments can be made that mediation agreements in consumer contracts are procedurally unconscionable. First, consumers must accept the terms and conditions to use the product or purchase the product. Consumers often do not have the opportunity to negotiate these terms. Consumers do not read these terms, as shown by the studies, and often are not required to sign the contract at all. Finally, consumers are not given an explanation as to what the terms mean or what their legal impact is. For mandatory arbitration clauses, the following have been substantively unconscionable depending on the facts of each case. First, short time limits for filing a claim. For example, an arbitration agreement could require that the demands for arbitration be communicated within 30 days after the claim accrued. Now, this clause is too one-sided towards the company. The claimant would not have enough time to properly assess their situation or obtain counsel. Courts are all over the place with this. Some courts think 30 days is long enough, while other courts think that any time limit shorter than the applicable statute of limitations is unconscionable. Second, imbalanced cost-splitting provisions. Arbitration agreements cannot contain cost-splitting provisions that would put so much cost on one party that bringing a claim would be essentially worthless. All this does is create a barrier to justice for those who cannot afford to pay. Third is impractical forum selection. Some arbitration agreements that contain forum selection clauses that are unreasonably far away may be substantively unconscionable. If it seems like the forum selection is far away for no reason and serves no other purpose than to dissuade people from bringing a claim because of travel costs, then it's probably unconscionable. Lastly, arbitrator selection clauses. Rather than random selection, a company could reserve the right to choose the arbitrators. Companies can use this power to choose arbitrators that are more favorable to their side. Sometimes arbitration agreements give claimants the appearance of a choice by allowing each party to choose an arbitrator from a pre-approved list. However, this requires that a party trust that the list of arbitrators created by the other is unbiased, and it only really gives the illusion of a choice. Furthermore, most people do not have the knowledge to make an informed decision when choosing an arbitrator. The same types of clauses, if included in a mediation agreement, could be substantively unconscionable. First, short time limits for beginning mediation. Even in mediation, a short time limit within which a mediation must begin could be substantively unconscionable if it doesn't give the party enough time to prepare or find counsel. Second, imbalanced cost splitting. There are many free mediation services, but there are also paid mediators. If a company requires that a party pay an hourly rate for the mediator, and those costs are so high that they could act as a barrier to justice, then it's unconscionable. Similarly, requiring a party to travel far distances to attend mandatory mediation would also be unconscionable if the travel costs were high enough to dissuade a party from bringing a claim, once again creating a barrier to justice. Fourth, mediator selection. Party self-determination and informed decision-making are key components of the mediation process, and they are just as important during the pre-mediation stages, such as mediator selection. The mediator determines the style of the mediation and the procedures, so the parties have a clear interest in selecting a mediator. If the parties are to choose the mediator, they must have the opportunity to make a true informed decision, with enough time to make an informed choice. Lastly, mediation arbitration. Now, when mediation turns into an arbitration if the parties are unsuccessful, it could make a court more likely to find the clause substantively unconscionable. There's been a lot of controversy over clauses like this, especially when the mediator becomes the arbitrator. It's important to note that there is a strong public policy in favor of alternative dispute resolution processes such as arbitration and mediation. The unfairness in the terms of the contract must be strong enough to overcome that public policy. There's no bright line rule for how much unfairness is needed to be considered unconscionable. It's the typical law school answer, it depends, and every case is extremely fact dependent. Since mediation is a non-binding process, it is likely that more unfairness is needed to invalidate a mediation agreement than is needed to invalidate an arbitration agreement. So how much unfairness is enough? The Northern District Court of Ohio did invalidate an employee mediation agreement because it was unconscionable in Garrett v. Hooters Toledo. The mediation agreement was procedurally unconscionable because employees were required to sign it to continue employment, so they couldn't be considered for raises, promotions, or transfers without signing the agreement as is. The mediation agreement was substantively unconscionable because it required that mediation claims be filed within 10 days after the claim arose. There would be 2 mediators for each case, which had to be selected from a list of pre-approved mediators provided by the company. The employees had little time and guidance for how to choose the mediator. And the Toledo employees were also required to drive to Kentucky for the mediation for no apparent reason. And these requirements together were enough to overcome the public policy in favor of mediation, and the court refused to enforce the mediation agreement. So that's how you could argue that a mediation agreement is unconscionable. Thanks for watching!